Welcome to the Property Management Law Solutions training module on how to prepare a 3-day notice to pay or vacate. The 3-day notice to pay is required under Chapter 83.56, subsection 3, and it must be delivered to the tenant before any eviction action can be taken. It is very important to note that a defective notice to pay may result in the dismissal of an eviction action. A property manager can use either the 3-day notice form that is approved by the Florida Supreme Court or a 3-day notice to pay or vacate prepared by a Florida attorney. Here we have a sample of the Florida Supreme Court approved 3-day notice to pay or vacate. The notice must also substantially comply with 83.56 subsection 3, the language of which is provided. Keep in mind, Florida courts have interpreted the 3-day notice as it relates to legal requirements of what it takes to have a legally sufficient 3-day notice. In this slide, we have a sample 3-day notice to pay prepared by Property Management Law Solutions attorney. This notice takes into account a variety of Florida court decisions regarding what is a legally sufficient 3-day notice to pay. The slides to follow will help you understand more about that. First of all, it's important to know that you must name each of the tenants that are on the lease agreement in the notice. Ensure that you spell the tenants' names correctly. Seems simple enough, but if you misspell the tenants' names, it could cause a problem. Refer to your lease to ensure that the tenant names are spelled correctly. Also, it gives you an opportunity to make sure that the lease agreement also contains the correct spelling of the tenants' names. If there's a problem in this regard, you might want to seek legal counsel on how to deal with that. Next, you want to make sure that if there is a tenant that has been removed by an agreement of the tenants and the landlord and signed by those parties, that removed tenant does not need to be named on the notice, but you want to be sure that the addendum that changes the parties to the lease agreement is in fact legally sufficient to bind the parties and is signed by the parties. Keep in mind, even if a tenant has vacated the premises, you still want to make sure that you name that tenant in the notice because that person is still legally obligated to pay rent and thus they need to be named in the 3-day notice. Also, if a tenant who is on the lease is not named in the notice, not only will the notice be defective legally, but also you won't be able to evict anybody who's not named in that notice. Additionally, do not name mere occupants because they are not tenants to the lease. Do not name guarantors unless they're actually signing as a tenant in the lease agreement. Next, we want to make sure that the property description is accurate and complete. You want to look at the legal street address in the lease agreement, and you want to use that legal street address in the 3-day notice to pay. You want to include the street number, street name, unit number if there is one, or a building number if there is one, the city, state, zip code, and importantly, the county in which the rental property is located. Failing to accurately describe and name the street address of the rental property can cause delays or problems in the eviction action. You also want to make sure that the street number or unit number is displayed in a prominent location on the property so that the deputy can actually execute the writ of possession. If the deputy has a hard time finding the number, whether it's the street number or the unit number, you could run into problems with the deputy executing the writ of possession. Next is calculating the back rent owed. This is a very important part of preparing a 3-day notice. Keep in mind, you can only include rent that is owed and late as of the date of the delivery of the notice. Your lease agreement provisions are very important as it relates to what is defined as rent. You never want to include rent, fees, or charges that accrue in the future. You can only add those items that are accrued as of the date that you deliver the notice. As it relates to fees and charges, you can only include those items in the 3-day notice if the lease defines those fees or charges as additional rent. If you include a fee or a charge that is not defined as additional rent in the lease agreement, the court could find that that notice is legally defective and not grant your eviction. There's a special note here as it relates to notice delivery fees. There are some lease agreements that will provide that the tenant pays for a notice delivery fee if the landlord has to deliver that notice. Keep in mind, there are issues regarding the timing of when that rent is owed or that additional rent if it's defined as such in the lease agreement. The best practice here, or the safest practice, is not to include the notice delivery fee in the particular notice that you're delivering. You will want to wait to charge that notice delivery fee whenever the next rent due date occurs. Also, of special importance here is that verbal tenancies can never include fees and charges that you would consider additional rent. Why? Because there's no lease agreement in place. The only time that you can include fees and charges are when the lease agreement defines those fees and charges as additional rent. So, with verbal tenancies, since there is no lease agreement, you cannot include those items in the 3-day notice.